Legal expert and commentator Mpumelelo Zikalala joins us now to share his views on these developments. A very good evening to you, Mr. Zikalala, and thank you so much for speaking to us. Dr. Phalatse was removed as mayor in a special sitting on the 30th of September. She says the council speaker, Colleen Makhubela, had an ulterior political motive when what she calls unlawfully called for an extraordinary council sitting which saw her being removed as mayor. To your mind, was the process unprocedural?
Well, it would have to depend on the standing rules and orders which are then applicable to the Johannesburg municipality. If a meeting can be called on an urgent basis and they're given a limited amount of time, then that's exactly the procedure that they would have followed. However, you must take note of how this particular matter is going to go to court. It's going on an urgent basis, meaning there are two legs. Before you even answer the question that you've asked me a few minutes ago, the first question or the first hurdle that the previous mayor will have to go through is the issue of agency. She will have to show the court that she's going to suffer irreparable harm. There are no other alternatives which are there that can remedy this particular harm. There's a certain interest in which they are seeking to protect. And the most important question to me would be, from the date of Friday, since you were removed as the mayor of Johannesburg up until now, what are the steps that you have undertaken and the activities that you have engaged to make sure that you're able to protect your legal interest? If you don't pass the agency battle or the agency hurdle, then your matter is simply going to move over to the ordinary role without the element of agency being considered. So it would mean that the current mayor will have to continue, the status quo will continue up until these particular procedures are then heard. Now, when they look into the merits of the matters, must be separated into two parts. The first one is to say, were things done in a correct and procedural manner? If the answer to that is yes, then obviously she's lost her case. But if the answer to that is no, then you have to go back and say, in what parts in which we did not comply with the standing orders and rules which are applicable? Is it something that has been done before that a meeting is called within 4 hours, for example? So those are the type of things in which they would need to be considered at the end of the day. And also taking from the interview that you've just heard, as the mayor, your allegiance is to the members and the people of Johannesburg and not to the political party, which is why when you say your allegiance and you take that particular oath, there's nothing which regards or talks about the political party. It is all about the members and the members of the public within the municipality in which you serve. So it may be even used against her in the reply to these papers when it goes back to court next week to say, in fact, you say the people of Johannesburg need you when you have clearly showed that you are not the person who thinks in the best interest of those individuals. The first interest in which you think about it is actually the political party that you're in and the members of your coalition.
I mean, she cites abuse of power. She has said in an affidavit, Phalatse, conceding that Makhubela had the powers to call a special sitting. But she says she took issue with the importance of the matter to be discussed, which was the motion of no confidence against her. Phalatse saying that despite these powers and council rules, they did not specify the notice that must be issued for the sitting. The councillors were supposed to be allowed at least 3 days to prepare for the meeting. I'm just wondering, how important would all of these factors be for the court to consider when they look at whether anything untoward occurred in the run-up to her being removed from this position?
It becomes more or less a textbook exercise, which talks precisely to the standing orders and standing rules which are then applicable. So you then have to say, what time must be allocated to a meeting when it's been called? Must you be specific in terms of the agenda of the meeting? If it is to deal with the matter which they deem as important, is there adequate time or enough time or some time which must be given, or a certain period which must be put aside for members to go and prepare? If there is none, and it is only your subjective opinion that it is such of an important that 3 days ought to have been allowed in order for them to prepare, then it's not going to suffice. Because the only thing the court is going to look at is going to say, what are the standing orders of the Johannesburg municipality? Yes, the meeting can be called within an X amount of time. Was that complied with? If the answer is yes, then the meeting was called procedurally, and there's nothing that you can falter in terms of the procedure that was followed. If you want to move on to the merits of the matter, or maybe to the rationality of the decision of calling a meeting as such in a hasty manner, and I say that in inverted commas with caution, then you must then go back and say, the people that were taking those particular decisions in that meeting, when it comes to the element of rationality and reason, did they really apply their mind to what was being handed over to them? Was it within their powers to decide in that particular manner? And if the answer is yes, they exercise their powers and their duties in the proper manner, then her application stands to fail. But if she can prove that certain things were not being discussed in a proper manner, individuals that actually took the decision and voted were actually doing so not in the best interest of the people of Johannesburg, then maybe she may have a case. But on this one, from afar, it does look like she's fighting a losing battle. If you look at the procedures that have been followed, and most importantly, if you look at the amount of time that has left, if she does really intend to take this matter on an urgent basis, I would have really expected that if the meeting took place on Friday, on Saturday, latest on Monday, then this particular application to set to go to court next week would have then been filed. However, how then are you going to explain these extra 5 days in the element of agency? Where is the agency in that? I think she will going to fail based on the element of the lack of agency before even the court considers the merits of this particular case.
Right. So Dr. Phalatse and her party, the DA, have also filed an application seeking to reverse her removal and Morero's election, including the decisions that would have been taken after he became mayor. What are the prospects of success, particularly on this, the argument about the decisions that have already been taken and the fact that Morero does not belong in that position? I know they are intertwined, but I'm just wondering about this.
The general rule would be that if a decision has been taken, it was flawed. All the decisions that followed after it must also be reversed. However, the courts have been very cautious in terms of saying, let's not provide a blanket revocal of all the decisions that have taken place. There are some that can be saved if it is found it is in the interest of justice that they be preserved. For example, if it's matters which is going to impact a number of individuals and a number of community members are going to suffer at the end of the day, let's save some for the sake of making sure that we're able to move forward. But in issues in which it is critical, then those ones they can be easily to attack and be reversed. I think on specifically on this particular matter, the most important one for the Democratic Alliance would be the election of the mayor and the election of the executive committee and all the other decisions in which they've taken place, which maybe would have attracted many monetary obligations or similar instances. But when it comes to matters in which the community must benefit, I think the court would be very skeptical in providing a blanket disregard or declaring of those decisions as being unlawful or not inconsistent with the Constitution. So they would engage in a process of looking carefully as to what exactly do these particular orders look for, and then the court will apply its mind.
Well, thank you so much for your time. Legal expert and commentator Mpumelelo Zikalala. Of course, Dr. Phalatse and the DA are also arguing that the DA members who were present at the meeting were not given an opportunity to speak or even break for a caucus to discuss the matter before them. So we'll keep a close eye on these developments. Do stay with us. More news.